All right, well, good afternoon, everyone. My name is Zach Baker, and I am the Development and Marketing Director for Alzheimer's Arkansas, filling in for Carolyn, who had another meeting today at noon. But we're excited that you are all here with us this afternoon for this exciting presentation on estate planning with Mary Nash, who we'll be bringing in just a second. We do have some exciting events coming up that we do want to let you know about. So this weekend in Malvern, Arkansas, we do have our drive-in movie at 7:30 at the Malvern Senior Center. Tickets are pay what you can, and you can purchase tickets by going to our website at alzark.org and then clicking on events and then movie. We also have in November, it's going to be National Family Caregiver Month, and so we have some exciting things planned for that as well. And we'll also have another drive-in movie in Jacksonville on November 14th during that month. So lots of great things coming up, but again, you can keep up with those if you go to our website, alzark.org. And you can also get updates from us if you text ALZARK to 51555. So you'll get text updates about our lunch and learns, our upcoming events, just a simple way to kind of stay in the know as to what's going on. And if you'd like to help support the work that we do here at Alzheimer's Arkansas, you can text ALZARK to 41444 to make a small donation today. Today we have with us Mary Nash, and I'm going to go ahead and bring her in with the Nash Law Firm. Hello, Mary.
How you doing, man?
I'm doing great. How are you?
Just great. It's a beautiful day.
Yes, it is. We're glad that you could be here with us today. And so I'm going to go ahead and let Mary take it from here.
Thank you, everybody, for having me here. And Bear, our Papa Legal, is here with me. You know, Bear and I always say that if you have a dollar and two relatives, you need to do some estate planning. People ask me all the time, what do you mean by that? Well, the last book that I wrote was on greed, talking about family fights after death. The one thing that we try to do here at the Nash Law Firm, an elder law firm, we do work for people who want to plan to protect their family. And what do you mean, plan and protect my family? Well, if you do nothing and you pass away with assets, to get those assets out to your family, you have to go through the process called probate. That is a court process where the court makes decisions about how things are going to be done. If you're in a blended marriage, for example, if you have kids and he has kids, if something happens to you and everything is jointly owned, it stays with the surviving spouse. At his death, it goes to his children. That's the law. It's your bloodline that passes the assets through your bloodline. So it would go to his children. Well, what about my children? I own half that property when we were married. You passed away, your interest moved to your spouse, and therefore it goes to his children. Well, how does it get to his children? It goes through probate. Well, if you do nothing, it automatically, that's the law, it automatically goes to his children. But it has to go through the probate process, and that's about a year-long process. Works like this. Someone has to go to an attorney. They have to file with the probate court. And my father passed away. He didn't have a will. And the probate court says, okay, we have to appoint an administrator, someone who is going to administer the assets as they move through the process. Of course, the court has control. And then at the end of that process, if there's real estate, you're going to want to keep the probate claims period open 90 days. That means the ad in the newspaper, then the claims period is going to run. And if anybody has any claims, they bring it there to the court and say, well, he had a credit card bill or he owed taxes or something like that. So that has to go through the period of that 90 days. If it's real estate, a small estate, that means under $100,000. It's going to take about 4, 5, 6 months to get the thing finished. If you have more than $100,000, that's a regular probate, and you're going to spend a year, maybe a year and a half getting it out to the heirs. And who are the heirs again? His blood relatives. Yes, but he has a son from his first marriage that he hadn't seen in 42 years. Doesn't matter. It is his son, and his son is entitled to his share of the estate. What if I have a will? We have people who come in all the time and they say, I have a will and I only have one child, so I don't have to do anything. Well, yeah, but how are you going to get it out to that one child? Well, I have a will, and the will says it goes to my child. Yes, that's true, but it still has to go through probate. Okay. What I say probate was, it is a court action. So you file the will, you have to get an attorney, file the will. If the assets are worth more than $100,000, we have a full-blown probate, which means when you run the ad in the newspaper, the claims period stays open 6 months. Okay. So, okay, now we're 6 months past death, a couple of months to find an attorney. We're 8 months before the claims period's over. Then we've got to pay the bills, wind everything up before we can distribute. So we're waiting again. So we talk to people all the time about getting a revocable living trust. A revocable living trust holds all your assets. Think about a trust like a box. Okay, so I'm gonna make a box, and I'm gonna put all your stuff in the box. And at death, it moves to your heirs without a court action. It just moves out to your son, your daughter, the grandkids, wherever you want it to go. About grandkids, what I always say is, if I'd have known how to have the grandson without having had the kids, I'd have just gone there first. So a lot of times we think about, I want to leave something to my children, but I also want to leave something to my grandchildren. And if you don't have kids, I might want to leave it to my brother, sister, my church, my best friend, my neighbor down the street. We just all have a different idea as to how we want things done when we're no longer here. What about while we are here? If we're incapacitated, we do a lot of guardianships. Grandma can't think for herself anymore. She can't manage her finances. Maybe she's not doing well health-wise, and somebody needs to make decisions for grandma as to how she's going to be taken care of. So we go to the court and ask the court to appoint someone in the family as her guardian, conservator, taking care of her health, taking care of her body, her person, and taking care of her finances. So there are a number of ways that we can handle planning during life. We can also do a power of attorney. Powers of attorney, are only good from the time a person becomes incapacitated, usually until death. Powers of attorney are not good after death. But we have powers of attorney for health care, powers of attorney for finance. You can handle my finances. You can go to Social Security and ask about my situation. You can go to my Human Resources office and ask about my benefits. So when you talk about elder law, it encompasses all of these things. Once in a while, we'll have a client walk in and say, Mom needs to go to the nursing home, and we want to preserve the family assets. We want to keep the house. We want to keep Mom and Dad's money. What do we do about that? We need to get them on Medicaid. Well, how do you go about doing that? Well, there's a lot of planning involved in that kind of thing. If you plan ahead, you can plan using a irrevocable Medicaid pre-planning trust. Well, if I do that, I have to plan 5 years in advance. So when clients come in and they've reached their maybe early 70s, even if they have no health issues at all, but they're really, really worried about what happens if you're on Medicaid in a nursing home, you can keep your house, but the state can lien that, put a lien against your house. You can have one car between husband and wife. You can both have prepaid burials. The one in the nursing home can have $2,000. The one at home can have half the liquid assets up to $123,600. So when you stop and think about that, that's not very much money to support the household when someone else is in the nursing home. So you've got to think ahead. Well, if you think far enough ahead, let's say the early 70s, no health issues of any kind, you might think about doing an irrevocable Medicaid pre-planning trust. If I can get all my assets in that trust 5 years in advance before I file for Medicaid in a nursing home, I can keep my assets, but you have to plan ahead. Okay? So to think about planning, the thing you want to do is to avoid probate if you possibly can. Set up your distribution so that everything you have goes where you want it to go, when you want it to go. And people will say to me, well, where do I want it to go? Well, I want it to go when I die. Maybe, maybe not. Maybe you have a spendthrift in the family who just runs through every dime they get their hands on. You might want to space it out for them over years. Or I have a 22-year-old grandson. I'm waiting to make sure that he learns about finances and how to handle his finances before I turn everything over to him. So I'm leaving him 5% a year, every single year, once he turns 30 and has a job and has a college degree. So yeah, all kinds of standards there. Some of us like to, control from the grave. And when you think about that, you want to think about, okay, my children, Do I have one that's maybe a drug user or an alcoholic that I wouldn't want to have a large sum of money all at one time? I can spread it out. I want to protect my children's inheritance when they get it from divorce, from lawsuits, from creditors, from bankruptcy, their bankruptcy. Or what if my child has an accident and ends up in a nursing home? I don't want the state to take their inheritance away from them. So I want to make sure that what they receive from me is protected. So we set up a living trust for the mother and father, and then we set up trust for the children as well, so that when mother and dad are gone, everything drops into trust for that child to take care of him. He's in charge of it, okay, if you say he can be. You can give it all to him at one time, so he has control of everything, or you can give it to him over time, as I'm doing with my grandson. And if my grandson shows me before he's 30 that he's perfectly capable of managing his own affairs, perhaps I'll give him control of everything. But that depends on the child and the grandchild. We can plan to leave our assets any way we want to. After all, it is our assets, so we can do with it as we please, including spending it all before we leave. And so we've got to think ahead about how I want things done. And husband and wife need to sit down together and talk about these issues. I always ask them, who do you trust the most in the world to make decisions for you? For example, if they have to decide where I'm going to live, if I can't take care of myself anymore, who's going to take care of me? What level of care am I going to have? How's my money going to be spent? And so I've got to appoint the successor trustee, the person behind me, to manage my affairs. I've got to appoint the person I trust the most in the world, because that person is going to be making those kinds of decisions for me. And then at death, I want to name the person I trust the most in the world to get along with their brothers and sisters to do the distribution. Now, I'm going to say how it goes. 10% to this one, 10% to that one, 20%, and we always try to think in terms of percentages because we don't know what we're going to have when the time comes. But what we want to think about is, how do I want to leave things? What percentages do I want to leave things, or do I want to leave a particular piece of property or a particular thing, especially personal property? That's where the big fights come in with the family. Who got mama's ring? Who got daddy's shotgun? And so we have a personal property memorandum in our estate planning where you can write down where you want individual things to go. I want my wedding ring to go to my daughter. I want my dishes to go to my granddaughter. I want daddy's shotgun to go to my son or my grandson, or the car. I had a client in here the other day who has a 1980 Corvette with 30,000 miles on it and two sons. And he says they're going to argue like crazy about this. And I don't know what to do. And I suggested he leave it to the lawyer. I'm sure he's not going to do that. But if he writes down where he wants that car to go, that's the end of the fight, because daddy said so. Okay? I might be disappointed in what daddy said, but daddy's the one that said it. He wrote it down. He said, this is the way I want things done. So we use the personal property memorandum to send out those special things that we've collected through the years to whoever we want to have it. And then we've taken care of a lot of the family argument. We've also made sure that everything we own is owned in the name of the trust, so that the trust controls everything. I'll have clients who say to me, well, I put my daughter's name on the bank account. I say, okay, what if your daughter says, when the kids ask her, what happened to the money mama had in the bank? Well, mama put my name on that account. She wanted me to have it. That's not why your name was on there, sweetheart. Your name was on there so you could help mom write checks, pay her bills, but you had an agreement, verbal though it was, that you would divide that with your brothers and sisters when the time comes. But greed kicks in and the child doesn't. So when we talk about having $1 and two relatives, we're talking about what you have and how you want to divide it so that you don't have any family feuds after you're gone. The one thing you want is to have your family still continue to love each other, get together for Christmas, get together for Easter, celebrate mama's birthday, those kinds of things as a family. And you don't want anybody mad at somebody because they went in there and got mama's ring, or they went in there and got mama's furniture. And so we have that happen all the time. We want to make sure that we've set everything up to go where we want it to go, when we want it to go, okay, at death, all at one time, or spread out over time. And we have the advantage of being able to plan during life. And I say to my clients all the time, If not now, when? All of us, I mean, I'm talking to you by television, okay, instead of sitting in front of you and talking to you. So when we think about estate planning, now's the time to do it. Now's the time. And those of us who have family members that are not able to make decisions for themselves anymore, let's get ahead of the game from now on. Let us plan in advance, okay, the way we to go, where we want it to go, when we want it to go. Avoid for family, whoever our successor trustee is, that person we trust the most in the world, it up and spitting it out the way we want it done. We want to be in control, okay? We want to fix it so there's nobody fighting about anything. Everybody's happy, having good memories about mom and dad. Mom and dad took care of us. They looked after us. They wanted to make sure that everything was the way they wanted it to be. And that's the way we want it to be, the way mom and dad want it to be, okay? You know, we want to make sure that everything is the way we want it. And I know people say, I don't want to control from the grave. Most of us do, if you want to know the truth about it. Okay, I want it to go where I want it to go. I want it to go when I want it to go, the way I want it to go. I don't want my son-in-law to get any of it. Okay, I want it to go to my grandchildren if something happens to me. And I can do all that kind of planning. I get to do all of that because I've come to an elder law attorney, and make sure that you do. We've written 3 books on it, you know, so we feel like we know elder law. We do this all the time. That's what I do. We, you know, work hard to make sure that our clients are happy with their estate plans. We review with them about every 3 years just to make sure that everything that they want to do, we've done. And of course, with the revocable living trust, you can always amend. You get mad at your son or daughter, you can always, you know, reduce their amount. You know, if something wonderful happens, you win the lottery, you can up the amount. And we think percentages, because you don't know what you're going to have when you're gone. So we try not to think in dollar amounts. We try to think in percentages. And so you sit down with your spouse and you say, how do you want to do this? What do you want to do? And then talk about it. If you have a child that's alienated from the family, you still have to mention them, because remember, they are in the bloodline. And so we say, you know, I'm disinheriting this person. I'm going to pretend they predeceased me and that they didn't leave any heirs. So I don't have to worry about that person swooping in. And we also put a no contest clause in the documents so that if they do swoop in and try to claim something, we have eliminated them. And if they claim something or try to file a lawsuit, they just lose their share that they weren't going to get anyway. So when you think about estate planning, folks, think about how you want things to go, how you want things to go. Who's going to take care of me if I can't take care of myself? Who will make decisions for me? What my level of care is going to be, okay? And how my money is going to be spent. Okay? And then think about at death, how you want things distributed, when, where, and protected. Okay? So think about all these things as you begin to go through the rest of your life. Now's the time to get this done. With this virus floating around all of us and all of us living kind of scared, you know, now's the time to get your estate planning done. If not now, when? Because this is the time. We all worry about our health, of course. We worry about getting older, not being able to take care of ourselves. So plan ahead. That is the one thing that we can do. We can plan ahead. And I encourage everybody, call our office, Nash Law Firm. We're at 501-851-0040. We always give a free consultation, about an hour of talking about you, your family, what you've got, how you want it left, you know, all of those kinds of things. We go through it, we think, pretty thoroughly. And then if you want to do it, we say, you know, let's do it. Usually the fees for a revocable living trust are somewhere in the 3,000s. If we're talking about an irrevocable Medicaid pre-planning trust, it's usually in the 4,000s, okay? Which is usually reasonable. And we want our clients to come, talk to us, tell us about your family. We'll tell you what the fee is going to be. It's a one-time fee. You pay half the fee to start. You pay the other half the fee when we get the documents done, which is usually about 2 weeks out. And then we have a number of meetings to review the documents, make sure you know what you're doing, what you have done, how your assets are going to be held, your name, comma, trustee, just to make sure that everything is in your trust and it goes where you want it to go when you want it to go. So call me, Mary Nash, at the Nash Law Firm, right? And come see me, spend an hour with me. We'll laugh and talk and tell jokes about grandkids and things, and about your estate planning. And when you leave, you're going to know an awful lot about how you want things done. So call me, okay? And if you have questions now, I'm here to answer it, all right? Just put those questions out there, and I'll answer them to the best of my ability. Just go for it, Zach.
Well, thanks so much, Mary. That's a lot of really great information. And, one of the things that I was thinking about was, as I was listening to this, is, it feels like there's a lot that goes into this, right? And so how early, it's too early to really start planning?
Oh, honey, no. Are you married?
No.
Oh, I can't believe that, Zach. A good-looking guy like you. When you are married, okay, and you begin to acquire assets, that's the time to start your planning. And definitely when you have a child, okay, because let's say you have a cute little boy like you. He's 4, 5, 6 years old, and something happens to your spouse. She gets run over by, a truck, let's say. And, here you are left with a boy that has to be, raised on up. And what happens if something happens to Zach now? I got to leave that little boy protected. I have to think about two things. Who's going to nurture him to adulthood? Okay, a guardian for him. Who's going to take care of his money? And we usually recommend that not be the same person. Okay, so we've got a financial person, that might be your brother, managing the money. Your mother might be raising the little guy. Okay, and so, the brother, she says, I need money for private school. Brother says, here it is. I'm paying the private school right now. He gets up to 16. He needs a car. Well, I'm going to find him an old clunker somewhere, and I can pay for it out of his money. So it's never too early to plan. I mean, even as a single guy like you, you've got a house, you got a car, you got money in the bank, you got an IRA, 401k. You want to make sure that it goes where you want it to go.
Right. Yeah, well, that's helpful information. I'm looking to see here. I don't see any questions. So if y'all have any questions, feel free to comment those real quick. And like I said, Mary will try to get those answered for y'all. But yeah, this was really great information. If you want to contact them, their number is right there on the screen. And then y'all have a website, correct?
Oh, yes, we do. Okay, there it is, www.mavellaw.com. Okay, and feel free to, call the office. Connie's our office manager. She runs everything around here. She's the boss, as we say. And you can always call Connie and make an appointment to come in and talk to me. It's always a joy to have clients come in and spend an hour with me. I learn a lot about everybody, and you can always call and talk to me. And we do a lot of phone appointments. People will call in and say, I want Mary to call me on the phone and let's talk about this. So we do an awful lot of those. We do a lot of Zoom meetings with our clients, who can't come into the office. So we're available by phone. We're available by Zoom. We're, available for people to come in. We go to their house. I love doing that. Where we go out and just sit down, and we try to be very safe. We clean around here so much that I had a client not long ago ask me if I got a new cologne, and he called it bleach number 5. So that tells you anything. Okay. And so we really like having people come in, but we're willing to go to their homes. We're willing to talk on the phone, same type of interview, as we would do if you were here. Or we can do Zoom meetings, either one. We just want people to plan. For God's sake, now's the time.
Oh, so we did. So I heard the pros, but are there any cons to the trusts?
Oh, to irrevocable trust? Okay, very definitely. Irrevocable means just that, irrevocable. Okay, you cannot change it. There are certain assets you can't remove from it. There are certain controls that you can't have, that you can have in a revocable trust. They're very complicated. They're much more difficult to manage than a revocable living trust. A revocable living trust, heck, man, I want to sell the house, I sell the house. I get rid of the kids, I get rid of the kids. I can do anything I want to do until, if it's a joint trust, husband and wife, until the first spouse dies. Now, with a revocable living trust, when the first spouse dies, because it is a joint trust, the trust cannot be changed. What it means by there is he can't, marry again and leave everything to her when we've agreed to leave everything to the kids. So it becomes irrevocable at that point. It doesn't give you any Medicaid protection, but it becomes an irrevocable trust in that it goes to where we sit it would go, not where the one surviving says it goes.
Yeah. Are there any other questions out there? Well, Mary, I don't see any more questions, so unless there's anything else you want to tell our viewers before we leave, I think we're...
Well, I just want to encourage everybody to do their estate planning now. Don't put it off. I know everything is hectic with the election coming and the virus and all of that, but we don't know what tomorrow brings for any of us. Let's plan now while we're able.
Absolutely. Oh, hang on. Steve said thanks, so there we go. All right.
Oh, great.
Thank
you for having me. I really appreciate always working with you guys. If you need me, call me for anything you need.
Yeah, and again, there's that number again at the bottom of the screen. Thank you again, Mary, for joining us today.
It's always my pleasure.
All right, and just as a reminder for everyone, we do have some really exciting events coming up. So again, this Saturday in Malvern, we are holding a drive-in movie at 7:30 p.m. It's going to be Beetlejuice. Tickets are pay what you can. We hope to see y'all out there. November is National Family Caregiver Month. So be looking for all the exciting things that we have planned for that. And then in Jacksonville on November 14th, we're doing another drive-in movie there. Again, tickets are pay what you can. For both movies, you can go to alzark.org/movie to purchase tickets. And again, thank you for